Thank you all for joining us today, both in person and online. It's been 2 days of rich, incredible, informative conversations, and it's wonderful to end the conference with the words of such esteemed guests. It is now my pleasure to welcome Dr. Bani Abawa, who will be moderating this session. Thank you.
Hello, thank you everyone, and thank you so much for joining us on a Friday. And we're really delighted to have you here. Like Maya said, it's been 2 great days of deliberation and discussion on human rights and democracy. But I'm very delighted today that we've reached the high point of our conference. We have a distinguished keynote speaker with a topic that I'm sure will interest all of us, given the times we live in and some of the issues that we've been talking about at our conference. It is my distinct pleasure to introduce Judge Chile Eboe-Osuji. Judge Chile has a very long resume, and I know if I attempt to read it in full, we might actually not have enough time to hear him speak. So I'm going to crave his indulgence to do an abridged version so that we can hear him speak. Judge Chile Osuji, Chile Eboe-Osuji is a judge of the Caribbean Court of Justice. He had really hoped to be here in person and has visited the McMaster campus twice, or even more than twice, I would say, but at least twice since we started thinking about this conference. But his current responsibilities at the Caribbean Court of Justice has made it impossible for us to join us in person, but he has graciously agreed to join us virtually. A brief background, Judge Chile Eboe-Osuji was the 4th president of the International Criminal Court. He is a distinguished international jurist at the Lincoln Alexander Law School at the Toronto Metropolitan University. From 2012 to 2021, he served as a judge of the International Criminal Court, first as a trial judge and eventually as an appellate judge. Prior to joining the International Criminal Court, Dr. Eboe-Osuji served as the legal advisor to the United Nations High Commissioner for Human Rights in Geneva. Earlier in his career, he worked at the International Criminal Tribunal for Rwanda and the Special Court for Sierra Leone as a senior prosecution counsel. He has authored several books on international law and human rights, including landmark titles such as End of Impunity, Holding World Leaders Accountable for Aggression, Genocide, War Crimes and Crimes Against Humanity, which is his most recent book, and 2 previous very impactful books, International Law and Sexual Violence in Armed Conflict, and Protecting Humanity, published in 2013 and 2010, respectively. It is my distinct pleasure to invite Judge Chile Eboe-Osuji to deliver our keynote talk today at the Democratizing a Human Rights Conference. Judge Chile Eboe-Osuji, the floor.
Thank you very much, Dr. Bawo. Can everyone hear me? I do not know whether you can hear me.
Yes, we can. Yes, we can.
Oh, fantastic. Thank you very much for having me today and for that wonderful introduction, Dr. Eboe. Yes, I know McMaster University very, very well. I know Hamilton just this week. Not only have I visited but on a couple of occasions I so happened to have my daughter there going to school. So I have driven to Hamilton very many times. Today, we, as you know, we what I call the crossroads of a civilization. We, all of us who care about human rights, have watched with great despair the trampling of the international human rights, international order in general, but human rights in particular, human lives being treated as, human beings being treated as if they're flies that could be killed just anyhow without accountability. People's homes and neighborhoods flattened and turned into rubble, again with apparent insouciance, as if civilization doesn't matter anymore. So that's what I mean by crossroads of civilization, and it's something that has been dispiriting for anyone who cares about human rights. It is so dispiriting that some people even begin to lose hope. I have in my encounters as a law teacher, as an international jurist, encountered frequently that note of despair. How can we count on international law to protect us when we are watching all these heart-rending events happening all around us with, again, carefree attitude to it? Some have even taken to despondency, to self-pity. In that order, do we hold out hope or do we give up? There's a good friend of mine with whom I get into that endless, frustrating discussion about this. And I ask, what choice do we then have if we are seeing all this happen around us? What is it up to us to do? Do we give up, knowing that giving up is exactly what those who are doing those things that trouble us want? They want people to give up on international order, give up on international law. What is the end result of that? The end result of that is, okay, people can do exactly as they please without even a modicum of pretension that there is any rule that should bind them. Now, in that aptitude or attitude of self-pity and despair lies certain errors of their own that perhaps we should all guard against. Professor Timothy Snyder of Yale University in 2017 published a little but powerful book titled On Tyranny, 20 Lessons from the 20th Century. And in those lessons of the 20th century, the cost of those lessons is do not obey in advance. And he put it this way. He says, most of the power of authoritarianism is freely given. In times like these, individuals think ahead about what a more repressive government will want and then offer themselves without being asked. A citizen, Professor Snyder continues, who adapts in this way is teaching power what it can do. A citizen who adapts in this way teaches power what it can do. That is, we anticipate what power will want us, that the authoritarian power will want, and then we do it. Or authoritarian power knocks at the door and we fold over and say, what's the point resisting? We might as well give in. That is what it means by adapting in a way that teaches power what power can do. A good friend of mine, working not long ago, having discussions about this and that about the world, not particularly on this, but also on this. And he makes the point that, look, sometimes we ask ourselves whether it is really wise to yield our lane. When you are in your lane driving and you see someone who should not be where they want to be in the lane, wanting to run you off your lane, do you readily yield your lane, or do you maintain your lane? It is a powerful imagery. So relating it to where we are, if we have norms of international order that have been established, we're all familiar with those norms, everyone is, but someone wants to destroy them, wants to erase them from the planes of consideration. Do we yield readily? Or do we say, well, yes, you may want to do what you want to do, but we do insist that there are some rules that guide humanity. There are rules that guide civilization, and we do insist on preserving those rules, even though you may not want to preserve them, even though you may not believe in them. We do, and we are going to insist on preserving those rules. Yes, there may be tensions, there may be questions about power of authoritarianism and other things. Are they so overwhelming in the moment? But then we ask ourselves, have we not seen this before? Has the world not seen instances where authoritarians try to run everyone off their lane, but eventually, as a good old Chinese saying goes, this too shall pass. If we readily yield our lane, it becomes more difficult to reconstruct it later on down the line when this has passed. So, another lesson from Professor Snyder from his book. I gave you the first lesson from his book on tyranny. First lesson, as I said, do not obey in advance. The second lesson from that little book of his is defend institutions. Defend institutions, again, he elaborates it in this way. He said, it is institutions that help us to preserve decency. They need our help as well. Do not speak of, quote unquote, our institutions unless you make them yours by acting on their behalf. Institutions do not protect themselves. They fall one after the other unless each is defended from the beginning. So choose an institution you care about. It could be a court of law, it could be a newspaper, it could be a law, it could be a labor union. Take its side, unquote. That's again Professor Snyder's second lesson from the 20th century on tyranny. So these are words again to keep in mind in moments of great despondency as the one we are going through. Now, when I talk about maintaining our lane, one question becomes, of course, I may have already alluded to it in the past, would be what lane is that we ought to maintain? I will deal with that briefly. And then the second question is it possible for us to improve on that lane in the context of accountability for gross human rights violations? First, what lanes do we have to maintain? I've already, as I said, alluded to that lane in the past. This would be the lane of international order, the lane of rule of law, the rule of international law that protects human rights. That lane was solidly established after the Second World War, after a great moment of tyranny around the world as well. We had the regime of international human rights law established since 1948, 1949, up until now. That lane of international order also contained norms like crimes against humanity, no longer allowed as a behavior in our civilized order. That lane contains norms against commission of war crimes. That lane contains norms against commission of genocide. So these are all part of what comprise the lane that we must maintain. Now, going back even a little further than that, another period of great despondency that the world had established. I mentioned where we are. I mentioned where we are now. I mentioned the period of Second World War. Now, going further back than that to the period of the First World War, when it all ended again, when those who lived through the First World War were living through that experience, it looked as if it would never end the same way we are feeling now. But eventually it did come to an end. And then the world learned some lessons, and out of those lessons came certain norms that the world needed to preserve. The first international organization was established after the First World War, the League of Nations. Out of that, also, we had the idea of accountability for a violation of international criminal law. The book I wrote that is in the background there, End of Immunity, that Professor Eboe referred to as my last publication, is a book that tells the story of how the world came to establish norms against immunity of even the most powerful heads of state in the world. At the time, First World War, we'll all recall that it was the Kaiser of Germany that needed to be prosecuted for war crimes. There was no precedent in international law for establishing an international court, let alone seeking to try a head of state before that international court. That it was a period of despondency, the First World War, that gave impetus to the creation of those norms. So the first time it was conceived that there should be an international court, and that international court should have the jurisdiction to try the Kaiser of Germany, and he would not enjoy immunity before that court. That is the story of the book, End of Immunity. A book, you can pick it up, it's on Amazon.com. It was written not for lawyers. It was written for any intelligent person who has university education, can read it and take lessons out of that. So that was a lesson from, again, period of despondency that befell the world back then. That lesson was consolidated after the Second World War with, again, the trial of the Nazi leadership. The surviving members of the Nazi leadership were tried at that time before the Nuremberg tribunals, as you know. That now gave the impetus for creation of the International Criminal Court. All that development starting 1919, moving down to 1945, laid the groundwork for establishment of the institutions we now recognize: the United Nations, the International Criminal Court, the International Court of Justice, and so on. So again, these are lessons we learned from dark periods of our history, global history. Now, so those are the lanes, some of the, what I mean by the lanes we must preserve, that we must insist that even though there may be some who do not want to recognize them, it behooves us to insist on that recognition, however difficult it is to insist in that way. Is it possible for us to improve that lane going forward beyond the norms of accountability using international criminal law? That perhaps is the next chapter in the developing of international law, the international norms, the international order. There is the next book in the works. Is a book on peace as a fundamental human right. The most basic of human rights is peace. But the international order, the international law, has not quite recognized peace as a right at all, let alone the most basic of all rights. So that is the next project that I'm working on. A book hopefully will be coming out in 2 or 3 years on that topic. And the point of the book, again, is really to say, well, we have, well, if we go back to the speech of Franklin Roosevelt during the Second World War, January, I believe, the 6th, 1941, when he gave his the Four Freedoms speech to the US Congress. In his Four Freedoms speech, he identified 4 rights, or freedoms. One would be right of the freedom of expression and freedom of opinion. That's one. He said there was a need to establish that everywhere in the world, he said. The second was freedom of worship. People needed to have the freedom to worship as they pleased anywhere around the world. The third was freedom from want anywhere or everywhere around the world, and freedom from fear everywhere around the world. So these were the 4 freedoms that FDR laid down in 1941 in his Four Freedoms speech. Now, out of those, out of those came the fuller body of international human rights norms that we know. That was blown up in 1940 in the Universal Declaration of Human Rights that elaborated these 4 freedoms into what we now understand as various freedoms. And 1948 or 49, the Universal Declaration of Human Rights, we've since had the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and a host of other human rights flowed from all of that. Now you ask yourself, all those rights, all of them, which amongst them can you really meaningfully enjoy in circumstances in which there is deficiency of peace, in circumstances of violent conflict? Which human right can you really, truly, meaningfully enjoy? Is it your right to life? Is it your freedom of movement? Is it your freedom of commerce? Is it your right to property? Which can you really meaningfully enjoy without peace? If the answer to that is head scratching, or blatant, no, there's none that you can really meaningfully enjoy without peace, then that gives peace its own value in that order of human rights. It is for that reason that I say that peace is the most fundamental of all human rights, bar none, and it deserves to be recognized as such, and not just recognized as such in beatific tones, in as if the Pope or Mother Teresa will be talking about peace. It is time to give peace an actionable value, actionable in the sense that its violation should result in legal discomfort to the culprits of that violation. So that will be possibly the next chapter in the development of international law. So I'm going to, and protection of human rights using international law. I'm going to leave it at that for now, and I know there will be questions and answer after this. So as to give you an opportunity to ask your questions. And I thank you very, very much for having me with you in this exceedingly important conference, very vital for our times. Thank you.
Thank you very much, Judge Eboe-Osuji, for that stimulating talk. There's a lot we'll take away from that. Do not readily yield, even in moments of despondency like that which we confront in our world today. Defend institutions, choose the institutions you're invested in, and vigorously defend it, even in times of despondency. Preserve the lanes of human rights, civic inclusion, participation, that emerged from the ashes of the tumult of the First and Second World War. And of course, this that I find really fascinating, we've had conversation about this with Judge Eboe-Osuji, the emergent notion of the right to peace, which I think it's the ultimate human rights, because none of the other rights can be fully operationalized or enjoyed under atmospheres of conflict. And so we look forward to that emergent discourse. But Judge Osuji has generously agreed to take a few questions, and then we'll have a short panel discussion right after that. So the questions are open. I know there are people joining us online. If you're joining us online, please feel free to type your questions. The webinar is being monitored, and I will be flagged if there is a question, and it will be read. But for now, those in the room, there are two microphones on the left and the right. Feel free to approach any one of them and ask a question. Yes, Paul, please.
Hello, my name is Paul Marinovich. I'm the managing director of Participedia. My question will be brief because I find the title of the book fairly shocking, and I know it's written a few years ago, because we're in a time now where it seems like we're in a crisis of immunity because there are some with such a privilege. So your commentary on that would be most welcome.
Thank you. It was written, well, it came out last year, actually, in October last year. It is not, it cannot, well, I understand the sentiment that it is rather a title that stands out, but there is nothing at all shocking about it when you read what the discussion in it is about. It is simply that up until 1919, there was a feeling that heads of state enjoyed immunity from accountability for international crimes. And the book tells the story of the end of that acceptance of immunity for international, for heads of state who committed international crimes. It was a deliberate policy, a reform of international law, spearheaded by the most prominent leadership of the world immediately after the First World War. Prime Minister David Lloyd George of the UK, Premier George Clemenceau of France, President Woodrow Wilson of the United States, and Premier Vittorio Orlando of Italy. They were who you called the Council of Four at the Paris Peace Conference, the Versailles Peace Conference. And during that conference, Wilson, for the first time, an American president, sitting American president, traveled to Europe while in office. That was Woodrow Wilson. And he went there to Paris to create the League of Nations. That was his burning desire. But George Clemenceau and David Lloyd George were more interested in accountability in trying the Kaiser of Germany than in creating the League of Nations. So these two gentlemen insisted at the time that there must be accountability for crimes that were committed during the First World War. At some point, I'll stop at that. During the negotiation, the discussion, brainstorming about how to bring it about, the question was posed of Clemenceau. He says, look, he said at the time, yes, I do want to prosecute the Kaiser, but first I want to know what international law says about that. I have tasked some of the most eminent professors of law in France to study that subject. That was reported back to David Lloyd George during a cabinet meeting, that George Clemenceau wants to try the Kaiser, but he wanted to know what international law said about it. What was David Lloyd George's response? He responded this way. He said, yes, I also do want to try the Kaiser very much. As for international law, well, we are making international law. All that we ask for is that it be based on justice. We are making international law. All that we ask for is for it to be based on justice. That was a deliberate policy, a deliberate move by those who are controlling the international order at that time to say, we want to create a new international law, and in that new international law, we do not recognize accountability for anyone, be they the Kaiser, be they kings, be they presidents, and so on. So that is reflected in the title of the book, The End of Immunity.
Thank you very much, Judge. I have a question myself on international law. You've just talked about international law based on justice. But one of the things we've heard in the papers that have been presented at this two-day conference, a recurring theme has been the selective application of justice in conflict zones around the world. The theme of this conference is democratizing human rights. And it proceeds from the premise that there are deficits in the international legal regime, and it needs to be democratized. It needs to be made equally accessible to everyone. But I'll keep my question for now, because I think we have a question online that we want to take. So can we take the question from an online, someone following us online?
Yes, we have a question from an attendee online. They ask, can you share your thoughts for the future for peace for Palestine, as well as accountability efforts for those who have suffered there?
Can you read that again so the judge gets that?
The question is, can you share your thoughts on the future for peace for Palestine, as well as accountability efforts for those who have suffered there?
Thoughts on peace in Palestine and accountability for those who have suffered there.
thought for peace in Palestine, now I'm on the bench as a judge, I'm no longer as free to speak on these things as I used to be as an academic. But while I was in academia, I did, you can research my name and all these titles. I was clear in what international law said about what was going on. The International Court of Justice has rendered a number of judgments and opinions that must be respected. I am very, very clear about that. Now, my thoughts on peace for Palestine, I am very hopeful that it is possible to have peace in Palestine. We also have to recognize certain models that beyond now all that has happened in the past, it is possible to look at what happened between Belgium and the Netherlands. There was a point in time when the Netherlands were very resistant to the creation of a Belgian separate nationality. The area that's now Belgium used to be part of Netherlands until about 1839, 1840. And there was an arrangement that was agreed upon by the most powerful states at the time and Belgium itself. Anyone who studies that, how that came about, could see certain lessons that could be derived from that. But it is important that the two-state solution, there's no getting around that, in my view, personally. We cannot get around the two-state solution. That just needs to be. And we've now seen the movement in that direction with many more states now coming out that were resistant to the idea of recognizing a separate Palestinian state in the past, have now come aboard and done that. So there's a role, what I know, I say, all bode well for the idea of peace in Palestine. Of course, we know that the two sides have been in this intractable situation, as if the reign of what has happened has been internalized so much. The humanizing of human beings across the lines been internalized so much. It will require a serious effort on the part of the international community to try and deal with that. I also do think that we have come to a point where it is no longer sustainable, in my view, to say, well, we're going to leave it to the two sides to sort out, to negotiate their own peace. I think we've come to the point where the international community needs to be robust in insisting on what the order of peace needs to be between the two sides. It's not sustainable to say, well, we'll leave it to them to resolve. They haven't been able to resolve it for generations now. I don't know that there's prospect of leaving it to them to resolve on their own, whether that's going to solve anything in the short to long term. Or 200 years from now, we're still where we were 100 years ago. It's time to move on. I am hopeful, but it requires serious effort on the international community to make it happen.
Thank you, George, for taking that. Hope is what sustains all of us. So it seems logical to anchor any discussion, not just in Palestine, but anywhere in the world, on the hope that we can move on. There's time for a few more questions. Do we have any more questions?
While they're lining up, maybe I should take your question.
Yes, on justice, the equality of justice, selective justice. In one of the papers presented today, I think it was in the context of the Palestinian situation, one of the quotes that was put on the screen was a statement by someone who had been interviewed as part of a research. And the line was that international law are merely ink on paper. They're nothing more. We don't feel them. They're selective. They're not equally applied, and we see little significance in international law. So there is, you talk about despondency, George, there is a pervasive despondency, particularly those who bear the brunt of the inequities embedded in the application of international law. You seem to be optimistic about the hope that international law can ultimately resolve some of these issues we've all identified. But how do you respond to that pervasive feeling, particularly in conflict situations around the world, that international law just simply hasn't lived up to expectation?
The question, it goes back, Professor Eboe, to what I said earlier. We cannot leave it to international law or the international institutions to protect itself or themselves. As I started with Professor Snyder's quotes, that the institutions, he said, do not protect themselves. Institutions do not protect themselves. I seriously think it's a mistake for us to write nice, erudite, critical papers in the comfort of our offices and computers and studies, criticizing the deficiencies of international law. I think we should first of all ask ourselves, what have we personally done to sustain international law? What have we? Is it that all we can offer will be a critique of it is not living up to expectation? What have we personally done to support it? That should be the starting point. I do not want to plagiarize a famous quote from JFK. Do not ask what your nation can do for you. Ask what you can do for your nation. That exact notion applies to the protection of international law. What have we done to protect it? Are we just leaving it international law? Yes, protect us. Francis Bacon in his own time said it about justice. Look, if we do not sustain justice, justice will not sustain us. So it doesn't help to beat up on international law. It hasn't protected us. We first of all need to protect it, enable it to protect us. I think that is the starting point, in my view.
Thank you very much, Judge Eboe-Osuji. Do we have one more question? Okay, I think that's my cue that there is a question. Okay, so let's take that question.
We have a question from Vereen Shepherd. They say, I think staying in our lane is not an option. How do you see CERD and other UN treaty bodies in this challenge to staying in our lanes?
Why is staying in our lanes not an option?
Can you take that again? And Nadeem, it seems muffled when you speak. You go closer
Me?
to the microphone. Yes, go ahead.
So Vereen Shepherd asks, I think staying in our lane is not an option. How do you see CERD and other UN treaty bodies in this challenge to staying in our lanes?
Staying in our lane is not an option. How do you see CCRD?
CERD.
CDRD? Wonder what that-
CERD.
Yes.
Convention on Elimination of All Forms of Racial Discrimination, is that it?
I think that's what they're referring to. And other treaties, other UN treaties, how do you see them in the context of this notion of staying in our lane?
They are part of staying in our lane. I do not know why. I asked the question back, why would the questioner think that staying in our lane is not an option? I do not understand the premise of that question from that perspective. But the second part of the question about how do I see CERD and other international treaties, yes, they are part of what needs to be in our lane. And the idea of staying in our lane is simply to insist that there are international norms And those international norms, we insist that we are not going to abandon them because the going has, for some reason, got tough or rough. This is the time for us to say, when the going gets tough, the tough gets going. It is difficult, yes, but that is life for the most part. We don't just abandon, drop everything and run away because it has got rough. That is the easy thing to do. The more difficult thing to do is to say, well, yes, we know it is hard. Yes, we know it is uncomfortable, but we are going to insist that these are norms that were conceived of for a purpose. And as far as we are concerned, those purposes have not been rendered useless. They are still valuable. We are not going to give up because somebody is using violence to push us off the lane. I do not, again, I would like to know what was meant by staying in our lane is not an option. But
No, I think that clarification helps, Judge, because in some other context, stay in your lane could also be interpreted as meaning do not meddle in matters that do not concern you.
Fair enough. Okay.
Yes, if you see a egregious human rights violation happening outside your lane, don't be bothered about that. Just stay in your lane. But I think your message is different.
Yes. Yes.
Hold the line. You're saying hold the line.
Hold the line. Thank you. Thank you for that clarification. I think that's very, very important. Maybe I think the questioner and I are actually on the same wavelength, saying, look, we just have to insist on the preservation of these vital norms. That's what I meant to say by staying in our lane.
Thank you for that clarification. Thank you.
Thank you.
Do we have any more questions? We might have time for just one more. Yes.
Hello, my name is Sarah Perry, and I'm a PhD candidate in the Department of History at McMaster, and I'm a research assistant for Participedia. My question for you is, we're seeing a global decline in support for studying humanities and social sciences, it's been reported. So I was just wondering if you could speak to the importance of studying humanities and social science for democracy and peace. Thank you.
I think it is very, very important to study humanities and social sciences. I mean, these are part of what I do believe in the idea that we have to understand what we are as a human society for us to be able to organize ourselves in a way that maximizes the potential for all of us, in a way that reduces the frictions that exist between us, in a way that understands the world around us that needs to be integrated in our consciousness as we again align the world the way hopefully we think it should be. That is what humanities and social sciences do for us. It cannot be any other way in my view. It is regrettable, but then maybe it's a matter that if people are no longer studying it as they used to in the past, maybe hopefully it is one of those, cyclical things in the movement of society. Hopefully that, but it is, in my view, vitally important for humanities, philosophy, social sciences, sociology, political science to be studied in universities. Very, very helpful for us. Hopefully AI doesn't erase everything. That's a new difficulty. I'm sure Professor Eboe will set up his own a new conference on that.
Yeah. Thank you very much. And thank you, Sarah, for asking that question, because I have to say, much of the work that Participedia does and the Center for Human Rights and Restorative Justice here at McMaster University is centered in history and humanities and the social sciences. And I note that the judge himself often draws on history for his books. Your book, End of Immunity, is a historical excursion from the First World War to the Second World War. Yes, you frame it in legal, in the context of international law, but it's a very deeply historical journey of how human society and and our international politics has evolved. So I think it's important to continue to emphasize the need for that understanding of our past, of our humanity, to ground our appreciation of contemporary developments, and also to signal where we might go in the quest for solutions.
I completely agree with that, yes.
Thank you very much. I think that's about it for now, but it remains for me to thank Judge Eboe-Osuji for a wonderful, wonderful and stimulating talk.
Thank you very much. It's a great honor for me. I am very, very grateful. Thanks.